Welcome. I'm John Yacos of the law firm of John Yacos, and I have with me my attorney colleague, Shari Bornstein. Hi, Shari.
Hello, John.
And for a little levity in these very difficult times, for all you fans of Tiger King, hello, cats and kittens. So today, hope that's funny. Shari, what do you think?
It's funny.
Okay. Today we're here to discuss and provide some information with respect to support issues. I'm hoping that this presentation is actionable and practical. Right at this moment, it is April 18th, and we've been in this situation for a couple weeks now. So to the extent that there have been Zoom videos, I think I'm a little zoomed out. What do you think, Shari?
Totally zoomed out.
Yeah, and a lot of content is out there with respect to parenting. But what Shari and I thought we'd like to do is discuss an issue that is going to become more and more relevant during this time period, but also moving forward after, and probably will be consuming a lot of our activity as the year goes on with respect to support. Because I imagine that a lot of you have financially suffered through this difficult time. And as a result, there have been changes in usually your income, could be financial resources with respect to assets and accounts. And you may have support obligations that do not reflect what your current income is or what your current asset portfolio is. So keeping that in mind, I anticipate that there will be a lot of activity with respect to modifications of existing support obligations, and we'll be talking about that. So just in terms of my background, I am a New York-based matrimonial and family law attorney with approximately 30 years of legal experience, and my practice is exclusively focused on matrimonial and family law. And Shari, why don't you tell everyone a little bit about your background?
Sure. I'm also a matrimonial and family law attorney with over 30 years of experience. I'm also a mediator and I practice collaborative law.
Great. Thank you, Shari. And we work together and we try to, provide a comprehensive, representation of the full scope of the client journey. So to the extent that a person wants to engage in alternative dispute resolution through mediation or collaborative law, Shari is the expert. And to the extent that you're more focused on litigation, that's my background and experience. And I also do a lot of work with respect to consultations on individuals who are in mediation. Now, today's topic, as we indicated, is, as we like to say, how the current corona pandemic has impacted support issues in matrimonial and family law. Now, if you have questions and you want to contact us, feel free to do so. You can email us. That's probably the best way. It's John, John, at Yacoslaw, YACOSLAW.com. And Shari can be reached at SHARI at yacoslaw.com. You could also call us. We're able to field our calls remotely. 212-587-9560 is our telephone number. Now, in consideration of these difficult financial times, we're also temporarily waiving our customary consultation fee. So if you want to schedule a remote consultation during this time period, we are available to help you there. And this presentation is informational only. It's not legal advice. It doesn't establish a confidential attorney-client relationship. Although if we do have a remote consultation, we would establish a confidential relationship. Also, you should know that we previously recorded I think a valuable presentation on the parenting and custody issues early on. We know that that's still a significant issue for a lot of people. And there's a lot of takeaway from that is valuable, even moving forward outside the pandemic situation. Now, with this presentation, we've broken down into 4 categories. We'll be presenting a discussion, as I indicated, with respect to support orders or agreements, and that relates to child support or maintenance, with a specific focus on modifications of those orders. Then we'll be discussing the payment of expenses And that's a very important issue, because you should hear about how to manage the payment of these types of expenses that customarily you probably could manage, but now there might be some pressure with respect to your current financial situation. Third, we'll be discussing issues related to your health insurance. And finally, we'll be discussing bookkeeping issues. Now, with respect to any question a client has now or at any time, pretty much the answer can be boiled down to one of two things. And you should think about this when you're asking a question of yourself or your lawyer. Question is, how am I going to get from point A to point B, or resolve whatever the legal issue is? And the answer always boils down to two separate things. One, can you get the other person to agree with you? Right? That's a key thing. And how can you do that? What's the mechanism by which you're going to get the other person? A lot of people will tell us it's impossible. We can't do it. The other person's a narcissist. They're gaslighting. They're keeping information. It's not possible. But hopefully through our presentation today, Shari and I will give you some valuable tools to expand your arsenal with respect to your ability to get the other person to agree. Secondly, if you can't get another person to agree, then you're only, unfortunately, left with a judicial determination in litigation. Now, in support issues specifically, that could be a judge in Supreme Court, which is where married individuals go to get divorced. They also have the ability to go there post-judgment. Or in family court, the person who handles support issues is called a support magistrate. And a lot of individuals who were married in their divorce agreements have what's known as concurrent jurisdiction. So they have the ability to go either to family court or Supreme Court. It's beyond the scope of this discussion to indicate, strategically what that really means and which one individuals should go to, which court they should use. But they should just know that post-judgment, oftentimes in your agreement, you'll have the ability as a married, post-married person, post-judgment, to go to either family court or Supreme Court. Individuals who are not married, who have support obligations, can only go to family court. Now, second question with respect to this, other than do you have a agreement or an order, because that will sort of dictate what your journey is and the availability of court. The second question is my support obligation paid through what's known as, in New York State, SCU? That's Child Support Enforcement Unit. It's a bureaucratic agency of the state, which allows for individuals to pay into that and pay their support obligation, and they provide for accounting, they provide for enforcement, and then they will pay the person who is the recipient of the support. And whether you have your payments through SCU or not will dictate your ability to modify your agreements independent of the court, because there could be specific, provisions within your agreement which allow you to do that or not. Alternatively, if there is no existing agreement or order, and you could be in one of two situations: either your support could be currently paid informally between parties, or there could be a situation where there's been no support paid, but now because of the coronavirus pandemic, there's a need now because you've lost your income, you've been furloughed, your financial situation has changed. So that might be a situation for a lot of individuals, and that's something that should be considered as well. Most significantly, I think, as I indicated, that I think modifications are going to be a key focus on our presentation today, but also I think a lot of parties. And any modification relates to the legal standard, which is, has there been a significant change in circumstance? And that usually relates to a loss of income, but typically it could relate to other things that justify the court finding a significant change in circumstance. Another key component to that is the retroactivity of the support. And this is a key takeaway. What you have to know is that you want to establish the earliest, if you're seeking a modification, especially a downward modification, you want to establish the earliest date by which a court can award you a change. Or conversely, if you're seeking an upward modification or an enforcement, you want to go to court as quickly as possible to establish your retroactivity date. You want to, basically it means how far back can a court go with respect to assessing money owed. Shari, do you want to chime in on any point with respect to that, the modifications?
We'll talk about that a little bit more in my section, because retroactivity, when the court is not available to accept filings, is going to be a challenge for a lot of people.
Shari's absolutely right. That is one of the key struggles we have as attorneys with respect to this. And that's why you can always go back to that framework that I established, which is, can I get the other person to agree? Or what do I have available in terms of the court? So that Shari will talk about the retroactivity date and how important it is. But key takeaway, you want to establish it as soon as possible. So key point, file ASAP on that. Okay. Now, just very briefly with respect to an understanding of support, child support, and we are New York State attorneys, and this applies to New York State specifically. So an obligation with respect to child support specifically is an obligation that both parents have. And it's made up of two components, one of which is called basic child support. And basic child support relates to basic child support needs: food, clothing, shelter. It's a presumptive calculation based on income. So usually and it's also usually established that the residential custodial parent, the person who has the child or children on a primary basis living with them, is the one who receives child support. And there is a wrinkle, which is also beyond the scope of this, with respect to situations where residential parents have 50-50 residential care. So the takeaway on that is you have basic child support. When people talk about, I have child support obligations, and they give you an amount, that's usually only a reflection of what the basic child support needs are, or the basic child support obligation is, excuse me. The other side of child support, which can be significant for a lot of individuals, especially with young children, is what's known as the add-on expenses. Add-on expenses are expenses that relate to medical and childcare, and those are mandatory by law. And you have a whole host of discretionary add-ons, such as extracurricular activity, after-school program, private schools, summer camps, and it can be, as expansive as the individuals reach agreement on the discretionary add-ons. And if you usually look at the status quo and figure out, what are our child's needs, and you try to encapsulate them in the add-ons. Now, add-ons, unlike basic child support, is not based on a calculation of income. It's based on a comparison of income, expressed in a pro rata percentage. So simply put, as a hypothetical, if one parent makes $60,000 per year and the other makes $40,000, together that's 100% of their income, and that their pro rata ratio is 60-40, something very simple like that. So you really, with respect to another important point, is that the courts have been limited, and I anticipate that there's going to be a significant change in the legal standard, being significant change in circumstance. This reminds me of what happened post-recession 2008-2009, where there is a legal standard on the books, but the court was aware of and sensitive to what everyone is going through, excuse me. So from that standpoint, please be mindful that there is a legal standard, and then there are actual people who are reviewing the legal standard, judges, support magistrates, who have been going through this in the same way we all are, and I think they're going to be sensitive to that. What you should also know in terms of this is, if you cannot reach agreement with the other person, what you have to do is you have to go to court, right? Or, as Shari will indicate, there is a succession or a progression of available resources. Now, what you should know about court is, one, up until now, they've been primarily relying on only hearing essential matters or emergency matters, very, very limited, and that everything is remote, so no one's going to court. And the second thing you should know is that they have expanded it and they probably will continue to expand it. The expansions have related to existing cases only, where the court can conduct conferences, or they can deal with pending motions that have been submitted. Unfortunately, the big takeaway is that for any individual who has not already filed and does not have a pending case in court, the courts have not yet opened up for those types of situations. Even if it's what can be perceived as an egregious violation of your parental rights, if you don't have an existing case, the courts up until now have tended not to deal with it. Now, there is still a lot of discretion. Attorneys can contact the court at this point and try to reach out to the court. We've gotten some information. Each county has presented the attorneys with information as to how to contact them. And you know, theoretically, if you do talk to an attorney, they may be able to you know, work with the court to get your issue addressed, even in the context where you know, it may not actually fall into the category of an emergency if you can articulate it something like an emergency, and if you get a judge who may be of the mind that this is significant enough to fall within that category. But the takeaway really is, if you don't have existing current case, it's going to be very difficult at this point to get into court. Now, your first priority should be to try to reach an agreement with the other person. Any agreement is only limited by your own creativity with respect to what the terms of the agreement are. You do probably need to make sure that you cross the T's and dot the I's with respect to the legal formality. So you might, it might be beneficial to discuss it with an attorney, because there are specific provisions that have to be in there. And also it does make sense to provide for basic amounts of support, because there are times when judges or support magistrates, acting within their discretion, want to make sure that there is some support provided, even if it's a minimal amount of support. Now, people can create temporary orders without even going to court. There's probably, for those individuals who have agreements or are post-judgment, there probably is some legal boilerplate in the back of your agreement, one of the last paragraphs, that says parties have the ability to modify their agreement without going to court if it's written and if it follows the same legal formality as the agreement, which generally means to get it notarized. And again, as I indicated, those people who are divorced and are post-judgment, you can go to family court or Supreme Court, but you can create, and I think this is a really important takeaway, you can create temporary orders. And these temporary orders can be done very creatively. For instance, if one party says, listen, a typical scenario that we've come across, I lost my job, or my income has decreased to such a degree, I can't really comply with my support obligation. Well, what you could say is, okay, we'll reduce it now, but when your income comes back, perhaps maybe you would get some of that money back. You know, you're preserving the right later on to go back to the established amount. You want to do that. You want to perhaps set up a recapture of amounts. And then another consideration is there may be a change when I was talking about the two components on the add-on side, you might want to think about this, that there's probably been a change in your childcare expense. With individuals who had a high amount or a large amount of childcare and an expense related to the childcare, you know, you may still have that expense, but in all likelihood, now that we're all remote, and you probably don't have that as an expense. So that, by its very nature, probably has changed the calculation and the amount on the add-on side. One final point before I pass it over to Shari is big takeaway: get everything in writing. Very important, right? That means when you're trying to work with the other person, try to put everything in emails. Text messages are okay, but get it in writing. And then as you're progressing through the process, if you're able to reach agreement or negotiate agreements, get that in writing too. That is going to be very important with respect to some sort of an indication to the court that you guys were working together. This is what your position is. So there's not going to be a lot of factual disputes later on when you do actually have the ability to go to court, if you have to go to court. Shari, do you have anything to add on that point or any other point that I've discussed so far?
Nope. I'll take it from here then.
All right, great.
Thank you. So there are several other topics that parties should consider. Parents really need to have an honest and open discussion with each other about the status of their employment and income so they can best plan for their children's needs. One parent, or tragically both parents, may have lost all of his or her income because a job has been eliminated, or as for many of our clients, a parent may be an owner or an employee of a business which is now closed or operating at a greatly diminished capacity, resulting in a pay reduction. If parents can't reach an agreement between themselves directly, there are other ways to reach an agreement. Let's start at the first step, though. Sequentially, parents really should try to reach an agreement between themselves. That is the most important way and easiest way to address this issue. Reminder, use positive communication. Don't let that relationship junk interfere with solving the problem, and that is coming up with an amount of support that will be shared between parents. If that discussion is not successful, seek the assistance of a mediator. If mediation is unsuccessful, seek the assistance of an attorney. An attorney can negotiate with the other party if that party is not represented by an attorney, or if there are two attorneys involved, the lawyers can speak and see if an agreement can be possible, and as John said, even on a temporary basis. If employment has been eliminated or if business has been impacted, it's important to apply for all benefits that are available, including any governmental programs specifically available as a result of this pandemic. This isn't just a practical consideration. It's important to demonstrate to the court that the parent who's suffered a reduction in income has taken every step possible to bring in money and provide resources for the family, even under these horrible circumstances. Also, it's important to stay current with obligations because conditions of the payroll protection program require that child support be current. So please keep that in mind. So let's talk about filing now. John mentioned that filing is an important piece of that. Currently, even though courts are not accepting new matters and access to court is restricted, there has been a lot of discussion among our colleagues and practitioners about the best way to maximize a party's legal position with respect to seeking a modification of support. I recently called the court's coronavirus hotline and with regard to support, and the person who answered the phone suggested that a party who is seeking a modification should go on the court's website, print out the modification form that's available, fill it out, and mail it to the court. And the court website is on, the form is on the court website, nycourts.gov. After the petition is completed, try at least to serve that petition on the other side in any way possible. Consider mailing it through the post office by certified mail return receipt requested. Also consider UPS or Federal Express, certainly more expensive, but you're still making the strongest possible legal argument that you've made every effort to serve and provide notice to the other parent to establish a retroactive date. In these unprecedented times, we don't know if courts will consider retroactivity to a date other than filing the petition. If the court has sufficient staff, maybe those petitions that have mailed in will have a date stamped on it, but we don't really know at this moment. So now let's talk about what happens if you are unemployed. If it's appropriate and you qualify, the next step would be to file for unemployment benefits. When you do so, print out all the documentation that you've gathered to support your claim for unemployment compensation and put it somewhere, whether it's an actual file or a file stored on your computer. While we can't predict what a support magistrate or a judge would decide at a hearing, at least you'll have all of the documents gathered in one place that you've submitted for your claim that you can provide at your eventual hearing to demonstrate that you've done all that you could do to show that you've lost your income. Please remember that even freelancers and independent contractors can apply for unemployment compensation at this time. So what you can do is run the child support guidelines based on your unemployment compensation amount. That'll give you some measure of what your support obligation is. If a parent has experienced a reduction in income, the parties can also run child support guidelines based on that reduced income amount. If it is impossible to comply with a court order in full, pay something to demonstrate to the court when you eventually get to a hearing that you did the best that you could do. Parties can also agree to a temporary reduction to a court order and agree in some fashion on how the amount that's accrued will be paid when the obligor returns to work. That would be an important task to undertake as well, or agreement to reach. You should also know that under the new federal legislation, parties can withdraw money from retirement accounts, and if they are under 59 and a half, they will not experience the 10% penalty that would normally have been assessed to them. And taxes that are attendant to that withdrawal can be repaid over a 3-year period. A bit of caution, though, is that when parties are calculating a child support obligation, the documentation that's submitted is a federal tax return, among others, is a federal tax return. And you're going to want to be aware of the result of that one-time withdrawal from a retirement plan as it impacts income. So be cautious of that when you're calculating a child support obligation down the road. So then we talked about bills. Some parents may not have a court order but share responsibility for joint bills such as a mortgage or a rent. Again, we recommend having a discussion and keep the focus on solving that problem, which is to decide the priority of payment of bills and how much will be paid. For example, both parties should agree on the plan to contact the bank that holds the mortgage on the residence and decide how much will be paid toward that monthly mortgage or whether it will be paid at all. Same discussion might apply to a landlord, having that same type of discussion. Both parties should be on the same page whether certain payments will be deferred and how the accrued amounts will be handled later. If one parent is able to pay an obligation in full, the parties should discuss how that parent will be reimbursed down the road. Parties should also discuss and consider how frequently and for what purpose charge cards will be used, especially if those cards are held jointly, and if necessary, agree on the limit of such use so that parties are not experiencing significant balances that can't be paid and that might affect credit down the road. The next topic is health insurance, another really important topic. In many families, one parent may hold the health insurance for the family or the children. And if that parent has lost employment and health insurance was a benefit of that employment, health insurance may no longer be in effect. If the other parent has the ability to place the children on that parent's health insurance plan, that possibility should be explored. The loss of coverage could qualify as a life event that triggers eligibility for coverage outside of the enrollment period without a court order. Parties can then discuss how the new premium for the children's portion will be handled. If neither parent has health insurance at this point, perhaps explore coverage through the Affordable Care Act or even Medicaid if that is a potential option. What you want to avoid is even a minor illness or injury wreaking havoc on a family's finances. So be sure to explore coverage that might be available to you. Bookkeeping, another really important aspect of all this. Much conflict arises from a lack of good bookkeeping practices. Parents should implement the best possible practices. Nothing causes more conflict than incorrect calculations when analyzing arrearages for repayment of child support or any other add-on expenses that are shared between parents. If you can, avoid spending money on legal expenses to calculate sums that one parent owes the other. These really are dollars and cents. Provide lots of documentation to your other parent or the other party. Supply receipts and proof of payment. If you both have the same information, it's going to be a lot easier to make those calculations. If you disagree about the expenses, such as whether expenses were reasonable or necessary, or they were mutually agreed upon, again, maybe think about engaging a mediator to assist. That would be a more efficient use of your time and your finances. Any agreement reached through mediation can be submitted to the court with a so ordered stipulation. So my final comments are these. We continue to navigate through these unprecedented times. As of today, the shutdown has been extended to May 15th. Our office receives almost daily updates about court activity and the types of cases that the court is handling. And we do appreciate that the courts are moving forward and attempting to address the needs of the public and the legal community. We recognize that life and expenses and support can't be put on hold, and people need guidance during these very challenging times. Best observation is to be practical, reasonable, and stay focused on solving the issues that you have. Be as concrete and specific as possible when speaking with the other party or your co-parent. Again, as John said, document everything in writing. And that concludes my portion of this presentation. John, anything else?
Thanks, Shari. That's great information. Yeah, a few concluding points. One is that the court has made clear that individuals' actions during this time period will be considered with respect to how they evaluate you as an individual, your reasonableness. So that's a further piece of information that's important to know with respect to trying to work with the other person, because they're going to be looking to see, did you try to work with the other person? Were you acting reasonably? And it has been made explicitly clear from the court that this is an important criteria when the courts open up, they're going to be evaluating this. Second takeaway with respect to what's going on now, two points. One is that I would not consider any change in residential, custodial, or parenting time to be extremely persuasive with respect to any application going forward. This is a little bit of a tangent, generally relates to custody and parenting time and modifications. But it also is important with respect to support if there's a difference in residential, if there's a change in residential custodial time. I wouldn't, be strongly advocating to any client that because you have more time now, because a child or children are with you and residing with you remotely, and that's changed something with respect to the parenting, that's really going to have a long-lasting effect after this. Same point with respect to changes in your financial circumstances and income. I don't think that the changes that have occurred to everyone during this period are going to be necessarily persuasive and dispositive basis for a modification. The courts will always look to a person in terms of what are you doing to reestablish your former income level. And they're going to put you through it. They're going to say like, okay, like Shari said, did you do everything you could during that period to seek assistance, financial assistance to the government and otherwise, any programs? What have you been doing with respect to seeking income during that period and subsequent to that? So be mindful of that there's still the core criteria for a person to maximize their earning capacity and to seek employment and to reestablish their income levels. So those I think are further important takeaways. And I hope that this presentation has been helpful and useful. We'd love to hear from you. So, if with respect to this presentation, and also if you need our assistance, we're here to assist you. Shari, anything else?
Yes, we use a cloud-based financial affidavit, a statement of net worth, and financial disclosure affidavit program. So if you need assistance, we can send that to you. You can get started on it, send it back, and we can be ready to get to court when the court doors are open for you.
Great. Okay.
Thanks.
That's it for us today. And thank you very much for watching. And please know that we will probably have some more helpful presentations on other subject areas as well. Take care and stay safe.
Bye.